Okay, we can get started. Hi everyone, I'm Anvesha. Welcome to today's session. So this is one of the free hackathon sessions for the open source AI hackathon. I'll start with sort of introducing the hackathon and encouraging all of you to participate. So the aim of this hackathon is to encourage individuals and teams to apply AI ideas and use cases to open source projects. The criteria are that the ideas and code should both be open source, and your code should be able to work with open source products, platform systems, and tools. The hackathon is open to pretty much everyone, whether you're a student, a consultant, researcher, professional, anyone can participate. There are five tracks to choose from. There's AI for scientific research, AI for inclusivity and accessibility, AI and creative expression, AI in education, and AI for India. We also have a bunch of very cool mentors. You can speak to them about your ideas on the Fifth Elephant WhatsApp group and sort of get help. And even these pre-hackathon sessions are aimed at sort of helping you learn a bit more about the various aspects of AI, LLMs, NLP, etc. Currently we have five mentors. Bharat Shetty, who is an AI/ML consultant, Abhishek Mishra, who's a PSF fellow, Aniket Maurya, who is currently the developer advocate at Lightning AI and the creator of Gradflow, Simrat Hanspal, who is currently spearheading AI product strategy at Hasura, and Sumod Mohan, who is the CEO and co-founder at Auto Info. You can submit projects as an individual. You could also have a team of up to three people. And I will share the submission link in Zoom chat. It's also available on the YouTube description. It's basically the project page for the hackathon under submissions you can submit. So for today's talk, we have Biju Nair, who's going to be talking about large language models and licensing. Biju Nair is the founding partner at Legalitech. If anyone has any questions, you can drop them in the chat in Zoom or YouTube or also under the comment section on the website. And I will pass them on to Biju. Over to you.
Thank you. So, good evening, everybody. My name is Biju Nair, and thanks, Hasgeek, for this opportunity. So, today I will be talking about large language models and the licensing aspect. So, at Legalitech, we work on anything around technology. We are lawyers, and some of the issues we will be discussing today, we have dealt with for some of our customers, clients, and this is from our experience. And the whole session will be around nothing around technical issues. It will be all either legal or commercial issues or business issues. So with that, yeah. So since we have large choices of large language models today, like every month we see new large language models coming up. How do you choose a large language model other than from a technical perspective? So you would be looking at aspects like the licensing agreements, whether that model is a proprietary model or it's an open source model. What is the data set which they are deriving it? Is it publicly available data set? What is the source? Whether there is any litigation around that? Then there are some ethical concerns also, like bias. There is issues, which the large language model poses. So how have they dealt with such issues? What are the regulatory implications? What is the regulatory compliance they have done? What is the royalty? So these are the broad considerations when you use any large language models you should be looking at, other from the technical aspects. So each has quite an implication because, for example, if there is bias, most of the constitution across the globe guarantees you fundamental right against discrimination. Like we have Article 14 in our own constitution. Like US also has their own, right, fundamental right against discrimination. So globally, this is an accepted norm, whether it is Europe or across the globe. that you cannot be discriminated or there cannot be any bias shown. And you also have seen there is so many litigations which is coming up, and this is all learning for us because with that you can assess what are the implications. In this today's talk, we will also be discussing some of the litigations also and understand what are the implications for and how do you choose. Uh, and the purpose of your usage is one of the most important things. So you could be using your large language model for commercial purpose, research purpose, or your personal use purpose. So the implications of each of those use is different. To put it simply, from a legal perspective, most of the copyright law, if the usage is for the personal use or non-commercial use, you can uh, get the exception under the copyright law. If it is for commercial use, then you don't get an exemption under the copyright law. So it is very important to understand the purpose of your usage. And most of these large language models, if there is a commercial usage, then things are different. There is sometimes limit also placed by these large language models, especially the commercial ones. So it's very important you should understand because in some startups case, some projects case, what happens is initially you might be only trying it out, but in future you might be looking it for a commercial use. You might be, on top of any commercial model or an open source model, you might be building your products or services. So in such scenarios, it is very important to understand and the implications of the use. So as I said, if it is a commercial use, you don't get a fair use exemption under the copyright laws across the globe. Across the globe, under the copyright law, if it is a commercial use, you don't get the exemptions. But it is for research purpose or personal use, non-commercial purpose, you might get an exemption. But that depends on case-to-case scenario. So when you are looking using it for commercial purpose, you should be clear about the subscription model, the usage-based model, the what is the fee, what is the upfront licensing fees, what is the restrictions, what is the limitations, what is the liability they have limited the usage from, what are the risks they would take, what is the direct, indirect, and consequential damages they would be taking up. So all those parameters should be looked into because sometimes there might be fine prints which you might ignore. But that has lot of implications from a legal perspective. You could be sued for not reading, ignorance of law is not an excuse. So you should be very careful and minutely understand what is the purpose, what is the short-term purpose, what is the long-term purpose of the usage, understand the fine print, read the terms of service of those large language models because as I said, there are hundreds and thousands of models which is coming up. Some are funded. Who is backing them? Whether it is corporate, whether it is governments which is backing them, like the case of Falcon, it is backed by the Abu Dhabi government. So each of those instances you should be careful about, and these are the considerations you should be looking out for. Now let's look at some of the commercially used large language models, like BERT, which is a license. So you will find that it's under Apache 2.0. Whether there is a restriction for commercial use, yes. What is the restriction? You have to provide attribution. Whether you have to do redistribution, the answer is yes. Whether you have to provide modification, when you do modification, you have to provide the modification notice, the answer is yes. So some of these obligations may not be easy for your usage. Or sometimes when you're using it and building products and services and this is being used by third party, they have also this obligation. So sometimes they may not be able to comply with these obligations. So be very clear, look into the license obligation, which is the license, what is the obligation, corresponding obligation of those licenses. It is very important on you to look into that and come to a decision which large language model is suited for you. The other scenario is of GPT-2, T5, and Blue. So this is under MIT license, which is a very permissive license. The only requirement is commercial use. Yes, you can. What you have to do provide attribution. Redistribution you can do. You can do modification. Yes. So this is one of the most permissive license you can think of in the open source ecosystem. And if you understand open source licenses, there are two types of open source licenses. One is permissive and one is copyleft. So whenever you hear the copyleft license, it is very easy to understand there are more obligations. Permissive, the word permissive means there are less restrictions and obligations on you. So MIT and all these licenses would be under the permissive one. Whether it is GPL 1, 2, 3, AGPL, all these licenses are under the copyleft. So there are more obligations. Okay, so let's see GLM 130B and new Memo LLM. So this is under GPL 3. So the commercial use, you can do it, but with source code. Redistribution, you can do, but with you have to provide source code. And this obligation is everybody who is using this software. So you might be providing this large language models to your customers, your clients. However, down the chain, they all have this obligation. So sometimes it may not be conducive for their usage. Like to give another example, in GPL 3, there is a patent grant back obligation, which you may not be able to comply with. So it's very important that you read the license, what is the restrictions, what is the obligations, and you meet that. Not only you meet that, your downstream, users also have to meet these obligations. So if they can't meet these obligations, you may have to look into another large language model. Then GPT-3 and Lambda and Coher. These are proprietary. So whether you can be used it for commercial purpose, the answer is it varies. They might put some usage restrictions for certain sectors, like medical purpose, you can't use it. Just an example. Redistribution, it varies. Modification, it varies. So there is no clarity here. So it is for the purpose which you're using it. So it might vary on basis on the purpose you're using it. So all these considerations should be looked into before you're using it. So now let's get into a scenario where we'll be talking about alpaca. So this shows this was developed by Stanford University. It is not used. It is not permitted to be used for commercial purpose for three reasons. One, it was based on another model which was Llama, which has a non-commercial license. So that's the reason you can't use it. The other thing is Llama instruction that is based on OpenAI's DaVinci 3, where whose terms in turn prohibit developing models that compete with OpenAI. So these are restrictions which you will fully find in the fine print. And if you're not careful, you can't use it. And tomorrow, once you build your products and services, somebody might point it out to you. So it's better to look it for these things, all these fine prints at the earliest stage itself when you're building the products and services. This also doesn't have the adequate safety measures for commercial use. So that's also something which is very important. So this is just an illustration of one of the large language models so that you can understand what are the restrictions, what are the obligations you have. Now let's look into ChatGPT. What are the limitations there? They themselves provide the limitation that it is not fully reliable. So, despite the fact that, despite its capabilities, ChatGPT 4 has a similar limitation as early GPT models. Most importantly, it's still not fully reliable. It hallucinates facts and makes reasoning errors. So, in case you are providing this services to, let's say, a banking ecosystem or a financial ecosystem, there could be litigations against you. There could be liabilities which could be imposed on you. Though there are regulatory bodies across the globe in various domains like financial and medical domains where you could not be using it because this the output could be as per their own limitation clause. They have stated that they could be not be fully reliable and there are limitations there. So in such situations, please avoid using such large language models. And there would be domain specific large language models which you could be looking at. The other largely used is Azure OpenAI. This also talks about that there could be uses of misuse of the system and it will have consequential impact on the life opportunities or the legal status. So it could be any of these issues. So you could be, sued because they would give up their hands and say that, we have already put out disclaimer on these things. So it is up to you to use it. And if there is an error or any issues, we are not liable for this. So it is up to you to use it, and you have to be careful about this fine prints. Now let's look into the usage. So generally, if it is an internal usage in the company, or it is personal use, or it's for scientific use, then things are different. But if you're building products and services on top of large language models, then what are the broader issues you would find from a legal perspective, from an intellectual property perspective? So one would be the intellectual property issues. So copyright issues, which entities like OpenAI already has faced. So as we speak, there are various litigations happening in US against OpenAI for the content. So many of the content has been used by OpenAI, and the content owners like New York Times have sued them. Various other content owners have sued them because the content does not belong to uh, OpenAI or any of these large language models. They have the content was the foundation models was based on learnings from the internet or from various other sources which were under copyright laws, which was protected under copyright laws. So, without the permission of the copyright owner, this was used. And this is used for commercial purpose. So, you don't get the excuse of fair use exemption also. Although the judgments and the outcome of these litigations are yet not come out, we are awaiting that. But generally, in these scenarios where the copyright owner can showcase that their copyrighted material has been used by a large language model and it's being used for commercial purposes, they can claim compensation, they can claim damages, and even they can ask the large language models to stop using their copyrighted product information or data sets for the learning. The other is that of attribution to the developer. If there can be issues where the developer who has worked on those projects, open source large language models, there is no attribution given to or her. The content ownership we have already discussed. We have already discussed about the litigations where the content owners have fought against these large language models. OpenAI case is known to everybody today. Some of the news channels, some of the content owners across the globe have sued them. Now, the liability of the large language models. So, if you look at any of the terms of use of any large language models, you will understand that they have limited their liability. So, if you look at OpenAI or ChatGPT, the limitation of their liability, direct, indirect, and consequential, is up to $100. I will show you the fine print later in the slides, where their maximum liability, direct, indirect, and consequential, is limited to $100. So if you're building a product and services and you're selling it to your customers, they may not, if you don't have the same limitation of liability of $100, which most probably they will not accept, you will be in suit. So it's better to read the large language models fine print terms of use. What is their liability they are incurring? So you accordingly you should also limit your liability. Otherwise, you would be incurring unlimited liability. And when litigation comes, sometimes the companies could be wound up also because they are not able to pay up the damages also. So all these considerations are to be looked into. The other consideration you should be looking into is many of the large language models can also invade privacy. So as you are all aware, there are various data protection laws regimes across the globe. Like we have Digital Data Protection Act, which has come into being. The rules are yet to be framed, but we have fundamental right to privacy, which is a constitutionally mandated by a judgment of the Supreme Court. So citizens have privacy rights. These are protected by various data protection laws. In Europe, they have GDPR. In California, they have California Consumer Protection Act. So such this data protection laws protect the privacy, and sometimes it is some judgments of the constitutional courts which protects those privacy rights in various jurisdictions. So many times the large language models have to be seen as violating the privacy rights of the citizens or the persons whose data has been shared or on the basis of which the large language model learned themselves. So such issues also could crop up. The other most important issue is also bias. So in case the large language model talks about in their terms of use that there could be a bias, please, and your usage is not internal usage, it is a commercial usage. I would suggest that please avoid using those large language models. So as we see, the large language models have some complex licensing rules issues. So we should not understand large language models in the realm of the traditional software we develop, because uh, there has to be a balance between the open usage and protection of the original work, because these large language models also has been built on data sets, and many of these data sets are copyrighted products. So it has to be a balance between the two. So permissive licenses are widely used, and which are what are the permissive licenses? As we discussed, the open source licenses can be broadly divided into two sets: the permissive ones and the copyleft ones. So permissive examples of permissive are MIT, BSD, BSD2 clauses. Now let's look into some of the commonly seen licenses in large language models. So if you see here in this slide, on the top is more permissive, which is MIT, BSD2 clauses. On the bottom, you will see less permissive ones. Now let's look into the user requirements. So Creative Commons 1, there is no requirement. So that shows that it is less permissive, more permissive, sorry. And if you look at the author requirement, there is no author requirement. Potential pitfalls, no significant pitfalls, but users should be aware it's not universally accepted in all jurisdictions. So that is one pitfall. If you see a BSD2 clause, retain copyright notice, list of conditions, and disclaimer in the redistribution. Now, if you look into Apache 2.0, what are the obligations on the users? Include copy of the license in the redistribution. If model is modified, change must be documented. Documentation becomes a challenge because each of your downstream users have to do this. So that in certain commercial scenarios, it may not be easy to document things. So that's the reason I try to showcase to you what is the user requirements, what are the author requirements, what are the potential pitfalls. So other potential pitfall is if it is under Apache 2.0, grant of patent rights can be impact business development. So if you can't take a patent on that subject matter, it might impact your users' rights. So they may not, you may not be interested in taking that license because it affects your patent rights. So in such scenarios, in a commercial setup, it may not be advisable to go for that. So let's say look at CCY, that is Creative Commons BY4. The user obligation is give appropriate credit, provide link to the license, indicate if changes were made, some additional requirements for derivative works. Author requirements include license text in distribution. That's okay. Attribution and indication of change can be burdensome. Additional requirements of derivative works. So if you see from this slide, you will see that any large language model, if it is under MIT or Creative Commons 1, there is less burden on the users and the authors also. So that is easier to use. If you use a less permissive one like an Apache 2.0 license, large language models, then the obligations on the downstream also is and on yourself is higher. And documentation and other things would add to the, make it very complex for commercial use. So all these things needs to be looked into when you're considering any large language model. Now let's look into each of those licenses, open source licenses, and see what are the requirements in specific. So one of the requirement for the user is any changes must be documented. Include a copy of the original Apache license in any use of LLM. Existing copyright, patent, trademark, and attribution notices must be maintained. Requirement for the author, provide a copy of Apache license, provide a notice file with above mentioned information. And as we discussed earlier, the express grant of patent rights to the contributor from the contributors to the users is one of the biggest pitfall. So this may not be could not be granted by a business because it affects their intellectual property rights. So it may not be advisable for them to use such large language models, which is Apache 2.0 license. Now let's look into some of the other licenses, which is BSD. So here the requirement is quite limited. You only have to keep the original copyright notice, list of conditions, and disclaimer. Requirement to the author is must the license text must be included in the distribution of the LLM. The other biggest pitfall in this case of BSD is there is an advertising clause that requires all advertising materials mentioning the LLM to display an acknowledgement. This can be sometimes be burdensome. But if it is for internal purpose and it is not for, it's for testing and other scientific purpose, things are easy. But if it is for commercial purpose, sometimes these obligations might be burdensome. So this is the other BSD2 like clause, which is quite light because it is very permissive. The only obligation is you have to keep the original copyright notice, list of conditions, and disclaimer. The license text to be kept in the distribution. This is very permissive, and so this can be used for commercial purposes. Similarly, BSD3 also, if you see, there is limitations for the commercial or promotional use. That could be a problem for commercial use. Yeah. So the other commonly seen license would be Creative Commons Attribution 2.0. So here the obligation is to provide appropriate credit, provide a link to the license, and indicate if changes were made to the large language model. Requirement for the author is the license text be included in the distribution of large language models. So if you understand, this can be sometimes very burdensome because you might be doing it, but your downstream users may not be doing it. And sometimes when you are doing a commercial product and services, making them understand of these obligations and ensuring that the downstream users do it is quite difficult. So from what I want to try to suggest to you is that despite the permissiveness, the in the commercial context, sometimes these license requirements can be cumbersome and burdensome. So, for example, Apache 2.0 and BSD3 that stipulates that any modification to the model must be documented. So that is burdensome. Creative Commons, 2.0, 3.0, and 4.0 mandates giving appropriate credit, providing a link to the license, indicating if any changes were made. So from this, the most user-friendly and less obligation and burdensome is MIT, BSD, two-clause licenses, which only mandates two things. You have to retain the copyright notice and the permission notice in the distribution of the model. So now, what are the other best practices for adopting large language models? So you should, as we discussed, we should look into the license, what are the license obligations on you? What are the conditions? What is the fine print? What is the liability? So as we discussed, OpenAI limits the liability to $100 US. What is the indirect direct liability? What is the consequential liability? What is the limitation of their liability of these large language models? In some large language models, this may be omitted. So then there is a risk. At least you know in OpenAI that the limitation of liability is up to $100. What about the content? Where has the content been taken from? Whether it was available, the content was created by themselves, or it was bought, or it was used from the internet. So all those things there would be in the large language models information provided. Please look into all those things. What are the things they have taken to ensure that there is data protection and privacy protected of the users? What is the statement regarding bias? As we already discussed, citizens across the globe has fundamental right against discrimination. So if there is a bias in that system, and if your purpose does not allow you to, and if you are using it for commercial purpose, I would suggest that you should not be using it, because that could be a scope for a future litigation on that. Please use it large language models from well-known and well-established open source projects, because otherwise there may not be continuity in support, continuity in vulnerability support patch, and so all this makes show that what is the contribution, whether there has been recent contributions by contributors. So all these are signs of, if there is no contribution in the recent past, that's a sign of, you should not touch that open source project for in regard to large language models. What is the regulatory compliance they are doing? Are they doing frequent regulatory compliances? And if they are not doing, they have been sued left, right, and center. Please avoid such large language models. Now let's look into some of the fine prints. You know, so this will be in the terms of service of all these large language models. So let's see some of the case scenarios also where they have been sued also. So ChatGPT says it's not responsible for the information it provides, as it only responds to prompts or questions given by people, making it difficult to hold it accountable for any defamatory statement made. So we are already seen there is a litigation against OpenAI where the first defamation lawsuit has been filed, that it responded to a false information generated by the ChatGPT. So a radio host in Georgia, Mark Walters, sued the ChatGPT, stated that Walters has been accused of defrauding and embezzling funds from a non-profit. The system generated the information in response to a request from a third party, a journalist named Fred Real. So already we have seen that ChatGPT, the output could be wrong. There have been instances where lawyers have used output of ChatGPT, and the ChatGPT created a fake case. And in the submission before the court, the written submission before the court in the case files, that was seen by the judge. And such, there was no, it was a fictitious judgment case which was cited in the by the lawyer. So it was an output of a chat GPT. So you have to be very sure that you read what is the liability, what is the accuracy of the output, because you might be using it, and you could be held liable for that. As we discussed earlier, the limitation of liability for OpenAI and ChatGPT is only $100. So this could be quite painful if you are using building products and services on top of any of the large language models, because your liability might be unlimited. So you could look into looking at models, but or taking an insurance to make sure your liability is limited, or you're safeguarded from your liability. And some of the other terms, if you see, which is of OpenAI, which makes it mandatory arbitration and class action suit waiver, limiting the option for the users to sue them. So all these limitations restricts the users from their usual rights to sue any entity. So the other thing could be you could be held responsible for the legal fees and damages if someone sues OpenAI or ChatGPT over the content you generated using their services. So all these fine prints, please read into it. Otherwise, you would be in a soup because you might be building products and services on top of this, or you might be using it for your professional purposes or any commercial purposes. If you're a professional, please make sure that the output is verified, cross verified. There is a human element, and wherever you are using it, please also provide that this has been generated by a large language model so that the user is clear about whether it was a human generated content or a large language model's content. So that should be very clear, and that way you can reduce your liability because at least you have informed the users about the content and where this has derived from. You have derived it from. So with that, I am looking for some questions from each of you. So one question I have for each of you is that how many times have you looked into the terms of use or terms of service of any of the large language models you have used? Hello.
If anyone would like to answer, you can unmute yourself and answer or even ask your own questions.
So I think I'm joined by my colleague Sukhan. Sukhan, you have any questions or you have any additional feedbacks, additional pointers?
Hi everyone. Biju, I can speak about something if there is a question, but in the absence of questions, we are staring at a blank wall here.
Hey Biju, Sumod here.
Hi, Sumod.
Yeah, so I have actually had a chance to look at once, maybe OpenAI's. But again, I think part of the problem was that um, it wasn't very clear. It is pretty, I mean, for a non-lawyer person, it's probably a little challenging. And to be honest, with the models being updated and OpenAI themselves updating their own, I think every few days or every few weeks, maybe I get update that their terms of conditions have, terms of service and conditions have changed, which makes it even more harder, right? So yeah, just a quick thing there. Yeah.
Yeah, I understand. The latest terms of service of OpenAI is in 2024. So,
I think yesterday or so when I logged in it again was saying that that it's again updated. So it's just too difficult to keep up. I mean, up to date.
yeah, I completely agree with you because, you have to be on top of it. See, the problem is when you're using it for commercial purposes, no? Each of those change will have a huge impact on you. And those changes are based on some litigations or some legal issues they have faced in some part of the world. So, if
Right.
you're using it for commercial purposes, you're building on top of, you know, a large language model, and your customers, your users could sue you. So, you have to be on top of those terms of use.
Absolutely, and not just that, even one more step ahead, right? Particularly for code generation purposes, one of the challenges that for me as a leader in technology is that the code it generates, if it's verbatim copy pasting, say GPL to code, if it's two small snippets, it's probably fine, but larger pieces, if it is almost similar to a GPA, GPL license code, then I have a lot of headache at my hands, right? And it's impossible for me to know whether any of which is from where. So that again adds another level of challenge, right?
Yeah. So
Not
I'll
just the
give an
licensing side.
example. During the COVID times, I had an opportunity to sue 18 banks and financial institutions. There, my client's library was used, and that library helps in generating PDF. So all the banks and financial institutions. So when we send them legal notices, we realized that when they responded back, they said, "We did not use it actually. We don't know about it. It was our third-party service providers and system integrators who had used it." So similarly, uh, but end of the day, the bank or the financial institution is liable because my client owns the copyright on top of it, and they have an obligation since they are using it. So I will go after the bank or the financial institution who's using it. I don't know who had inputted it, and only they would know who had provided that use that library. So for you, you can't escape from the liability. You can't disclaim that, and you can claim in certain scenarios where you are using it for research purposes. But if you're using it for commercial purpose and it's a commercial service you're providing, then you have to pay the damages. So, and you can't say that ignorance of law, I can be excused. No. Globally, across the globe, you have to do that due diligence. So I had an opportunity to write on this, which is called check before you ship software. So today, if you ship software and you have not taken the due diligence, then you can be sued, and you can be sued by multiple parties. Your competitor also can sue you because uh, so that happened in Panasonic versus Coconut case, where the competitor sued for 100 million US dollars, saying that the company did not do open source compliance, so they shipped the product faster to the market.
That's
So
a
the
very
product
interesting
is stopped by
take.
the customs department. Uh, so there are so many risks. So before you ship out, you should be, at least you should be able to showcase that you took the reasonable due diligence which should be have been taken. So that's why I gave the example of the lawyer using it, Chat GPT for in a case, and it was a fake judgment which was provided by the Chat GPT. So unless the human element of review or due diligence is not shown, the court will not be the liability you will be imposed, which will be much higher. If you can showcase that after due care and due diligence this happened, then the court might be lenient.
I'm actually aware of three instances where lawyers have misquoted cases from one of the AI text generators. When it comes to terms, that particular risk that we were talking about earlier, all of these companies that provide this as a service, their terms can be modified by them at any time. But if you are a big enough player yourself, if you have enough money backing you, then in that case, you can negotiate a custom agreement with them. I'm in the middle of an agreement negotiation with OpenAI on behalf of one of our clients right now. And there, the particular concerns of the client are being dealt with in that custom agreement with OpenAI. If you go for the generic terms on their website, they're applicable to everyone who is accessing their API and providing services based on that. But when you've got enough money backing you, everything becomes possible.
Let me maybe take a contrarian point of view. What happens if someone is instead taking the position that I mean, look at OpenAI data itself. That itself is not. I mean, there's quite a bit of copyrighted stuff there, which is exactly what the New York Times is fighting for, and not just there. Any of these models, right? I mean, it's just impossible now to take it out. One, and second, they also create second order or third order models, meaning a model that is generating output, which is then training a next model. At that point, is it any more copyright? This is like the ship of thesis, right? And So now in this mess of where copyright itself is sort of a lot more fluid than it used to be earlier.
Yeah.
A lot of startups founders are like, you know what, okay, I mean, here is an amazing opportunity. Let's just take the risk. We don't even know whether we'll survive. If we get sued, we'll see it at that time. What is your thought process around that? What are the risks with those? When will that catch up? Bar and yeah. So maybe I'll ask the remaining questions later.
Yeah. Sumo, there are two thought process on this. If the business revenue far outweighs the litigation cost, like when Samsung infringed upon Apple's design and patents, the revenue outcome was far outweighing the the actual damages they paid to Apple. So that is one thought process companies do. The other thought process they do is at least they take the basic due diligence, they see what is the risk, and then they also take additional liability insurance, litigation insurance, and liability insurance, so that even if the revenue which they derive, it is safeguarded from litigation through these insurances. So that is another way of looking at things. And the other problem which startup face also is that they're they are pivoting their business models. So initially they would have tried some large language models that fitted their bill, but one fine morning the terms of service changes. So you can't use it for any other purpose other than that particular purpose, and you are now going into a commercial usage or you are providing commercial services. So all this puts you in a difficult position. But the rule of thumb would be always read the terms of service, see what is the implication of that usage. What could be the maximum liability? Can you cover it by insurance, liability insurance? Can you, whether the cost of litigation or the revenue you get generate out of it is far beyond the revenue. So if the litigation is, let's say, the maximum damage is 100 crores, and but you are making 1,000 crores, then you can offset that.
Got it. Yeah, I think maybe, I mean, I think because all these are very early stage startups, right? I think their thing is that we don't even know what we're building, right? It quite possibly when we know what it is, at that time, maybe we'll get curate, much better data. We'll try to make sure that the models are probably compliant, etc. For now, let's not worry about it. And the other thing is also that with everyone else doing it, even the big wigs like OpenAI and all others doing it, because all of them are trained on all
Yeah,
publicly available data as much as that, right? Um, so that the thing is that, oh, let's not worry about it now. So in that, which I think is reasonable, right? I mean, your thoughts?
yeah.
I have some
So
thoughts
that's
on
why
this.
you will see the terms of service being changed by the OpenAI every every month, because
Got it.
they also not knowing what are the litigation which will hit them. So I showed you the defamation case, which they never anticipated. And that's why you would have seen there is an OpenAI commitment also. I think if you are a paid member, they will take care of the litigation expenses. So if you are a paid service member, but that is not applicable to if you are not a paid customer of theirs. So in scenarios where you can be a paid customer, please be a paid customer. And in scenarios where the risk is, or you can take due care and due diligence, I think then things are okay. But the minimum care, because even if you go to any litigation, whether it is a data protection litigation or any litigation across the globe, if you can showcase to the court that you have taken the due care, what was possible for you, then the damages or the compensation you have to pay is much lower.
Got it. Maybe one quick question there. What all conditions do they alleviate? I mean, alleviate your. I mean, support your legal expenses. Is it for data protection alone, or is it for other ones as well?
So the OpenAI one was for copyright infringement,
Got it. Okay. Got it. Okay.
but there is a rider there. It's only for their business clients.
Sure. I mean, I think at least for startups who are using it, they all are using as a API, right? So they all are business clients by default. Yeah, I think your colleague was saying something else.
The problem with copyright law is that it varies from country to country, jurisdiction to jurisdiction. Even if some of these countries rule that it's absolutely fine to do these things, some other countries might block it. If you're operating globally, then that becomes a problem unless you start blocking off certain countries from accessing your services. Right now, we're in the experimental stage. Everyone's trying to figure out what is okay, what is not okay. But I assume that in a few years, we'll see at least a few countries saying that this is not okay, while other countries like Japan have come out to say that this is absolutely fine. So we might see a difference of opinion across the globe on this particular issue of what data is okay to feed into a model and then use its output as long as the data looks different when it comes out in the output. If if a model is completely reproducing an entire book, then that is not going to be okay anywhere in the world. But other use cases are being explored. We can't say definitively whether something is okay or not unless we look at the particular use case. Then we could perhaps give an opinion on that.
Yeah.
Got it. Okay. One more
And
question. I mean, this is slightly tangential. I hope this is okay. Feel free to pass it and take other questions. What I mean, let's say I have a bunch of data. It could be a code. It could be anything essentially. And if I want to put a no AI training on it, is there a license today for that?
yeah, so you
And
could put some of these, like New York Times says that no AI training. So on their content, you can just put that code, and
got it.
that is an indication that you can't learn from my data sets or content.
Got it. So, as I mean, essentially, what you're saying is that it's just modification of their own terms of service more than anything else. Got
So it's basically a code, so you can't do data phrasing from their websites or their
got it.
content.
Okay. Okay.
Yeah, that's true. It's based on whatever you put in the license for that text or image or video or whatever it is, whatever the data is. Now it's up to the person who is taking this data into their model and ingesting it there. It's up to them to clean their entire input data set, remove everything that is not supposed to be fed into that data set based on its licenses. That's where most people are failing right now. You can put whatever you want as a license text on your outputs, whether it's a story you've written or code you've generated or you've written down. If you put it publicly, it's always possible that a road actor can come and take it and use it to train their data and not even look at the license. But that's something that is common across industries. It applies to software as well. If you put a particular license on it, you leave it up to other people to obey that license. Otherwise, it's up to you to track down who has infringed on it and then to sue them.
Got it. Thanks.
And Sumod, the Open AI Act of Europe would also provide some clarity, it's like against bias and all those things, no? So which is in the draft stage
Got
now.
it.
So once that, at least for the European region, that would be something worthwhile to look at. And there are some rules in New York, state-wise in US also. So all these things, if once it get enforced, we would be having more because most of the cases now have got settled. So wherever there is settlement, we don't get a judgment, or the matter is still pending. So I'm also awaiting curiously for some of the judgments to come out. So there will be some clarity.
Got it. Okay. What are some major ones that got settled? And do you know what numbers are we talking about? I mean, at least order of magnitude.
So some of them has been settled in US in some states. Some of them are still pending, and I'm awaiting for the European AI Act.
Got it. Okay. Thanks much, Anyusha. You can ask other
Yeah.
questions.
Yeah, no, I don't think we have any other questions. So, Sumod, if you don't have anything else, I think we can end the session.
All right, sounds good. Thanks all. Nice
Okay.
session, guys. It was very interesting. Thanks.
Thank
Yeah.
you.
Thank you,
Hope
everyone.
you will
Bye.
still use large language models. My objective of my session was not to,
Yeah,
stop
absolutely, right?
anybody from using large language models, but use it with due precautions, due diligence. That's the
Exactly,
only.
100%, 100% with you. I think just that awareness of what licenses
Yeah.
can do, what is a good measure. So that's a great thing that you did. Thank you. Bye.
Thank you. Good day. Bye bye.
Bye bye.
Bye.
Thanks, everyone.